Morning, Your Honors. May it please the Court, John O'Haron on behalf of Sherelia Smith and Natalie Staton. The District Court erred here by doing something that the Supreme Court of the United States has refused to do for over 40 years, which is extend a Bivens remedy to a new Bivens context. The plaintiff filed a First Amendment and a Fourth Amendment claim against my clients, both of whom are TSA agents. After correctly finding on our motion to dismiss that both claims presented new Bivens contexts, the District Court nevertheless proceeded and erred by holding that there were no special factors that counseled hesitation, by denying our motion to dismiss and allowing the case to proceed. We are now here on appeal asking this court to reverse that decision. The District Court's decision was error at the time it was made under Supreme Court precedent and this court's precedent applying Supreme Court precedent, most notably the Supreme Court's decision in Ziegler versus Abbasi. That error is even more pronounced now since this past June's ruling by the Supreme Court in Egbert versus Boulay. At the outset, the plaintiff does not dispute the District Court's finding that these two claims present new Bivens contexts. So the only issue on appeal is that special factors inquiry. The special factors inquiry, the Supreme Court in the Egbert decision this past June stated, really boils down to a single question. And it's answering the question, this court has characterized the Supreme Court's jurisprudence in this area as open hostility to expanding Bivens. The single question really is about separation of powers. This comes down to whether an implied cause of action can exist, and that question is, the Supreme Court has stated time and time again, in almost every single case going to be a decision for Congress to make, not the courts. The question really is whether the judiciary is well suited, here the District Court found that it was, to consider the pros and cons, the costs and benefits of extending Bivens remedies to a Bivens remedy to a new context.
I have a question about the special factors. What is the alternative remedial scheme here that FLAs could have undertaken?
So we believe there are two, and it's important to note that the alternative remedial scheme is analyzed at a very general level. It's not analyzed at a granular level. The Supreme Court has made clear that it might not include damages. It might not include the plaintiff's ability to participate. It might not include a right to appeal. So it might not map neatly onto the specific claims in this case. But that being said, there are two. One is the TRIP program, which is authorized by Congress under 49 U.S.C. 44926. And on its face, and the Third Circuit recognized this.
How do the FLAs participate in the TRIP program?
Well, the TRIP program, and as administered by the Department of Homeland Security, seems to suggest that any traveler who feels that they have been delayed for boarding their flight based on being flagged as a threat, and that's the term used, it might not map neatly, and we concede that. But it is. No, and I think if the plaintiff were to try to proceed that way, it may come down to, are you a threat by videotaping at the security station as alleged? And it might not be the case. But the point on alternative remedial schemes isn't sufficiency to the plaintiff. The point is congressional intent and deterrence to the federal officers. The other alternative remedial scheme that may be available is the complaint that the plaintiff could file under the Office of Civil Rights and Civil Liberties.
Was that option argued?
We may have only invoked the TRIP program. I can't recall in our motion to dismiss. I don't think it, I'm sorry, yeah, I don't think it matters. I think that if this court finds that congressional intent and the deterrence factor, that Congress has considered the issue of what rights to provide to travelers and has decided not to provide a cause of action, that's sufficient. And that can be a single and dispositive special factor that this court finds.
I want to make sure I understand what you just said. So you're saying it doesn't matter because of the TRIP alternative remedy, not because we should overlook the fact that if you didn't raise it below,
I think both. I think the TRIP program by itself is enough to show congressional intent and deterrence that Congress has considered this. I think even if we didn't raise the civil rights complaint in our motion to dismiss, it would be an alternative ground to reverse, and this court could find it. But the understood, and I think in that, the TRIP program is sufficient. My colleague from the Department of Justice that we're sharing argument time with is going to address perhaps the most critical special factor, which is the national security implications of extending Bivens to TSA agents. And then the Supreme Court case precedent also considers the impact on governmental operations more broadly, the system-wide consequences of extending Bivens to TSA agents. And here, that's a significant factor. What is going to happen if Bivens is extended to TSA agents? How might that affect training? How might that affect job performance? How might that affect civil liability for the United States government? To discuss these questions is to answer the dispositive question. To discuss the policy pros and cons itself is a special factor that discussion dictates this court must reverse the district court. And it is, the plaintiff disputes that it can be both congressional silence and congressional action, but that is indeed what this court has said and what the Supreme Court has said. The TSA was created in 2001, and since that point, it's been amended, the authorizing statutes have been amended many times, and Congress has never seen fit to create a cause of action against TSA agents. And by the same token, Congress has authorized certain alternative remedies for travelers who feel they are aggrieved, and their congressional action suggests that this court must hesitate. This court need only find a single reason. And it's not a single reason that a Bivens remedy shouldn't exist. It's a single remedy to think that Congress should be the one to consider it. It's a remarkably low threshold, as the Fifth Circuit has stated. This court has recognized that it is a remarkably low standard. And it is one that is we believe, easily met here. The decision of the district court should be reversed, and at this point, without further questions, I'll cede my time to the United States. Thank you, Your Honors.
Buddy, thank you. Good morning, Your Honors, and may it please the Court, Catherine Potty for the United States. As this Court and the Supreme Court have made clear, the key question in Bivens cases arising in new contexts is who should decide whether to create a damages remedy, Congress or the courts. As the Supreme Court just said in Egbert, the answer will be Congress in most every case, and that is especially so where national security is at issue. Thus, a Bivens remedy is foreclosed here when lawsuits against TSA agents for their conduct at airport screening checkpoints plainly implicate national security. I welcome the Court's questions.
Fair enough that TSA implicates national security. Is that our inquiry, or is the inquiry whether the circumstances about which this claim arose
The former, Your Honor. The Supreme Court was very clear in Egbert that this analysis is not to be conducted in light of the particular circumstances of the case, but rather at a broader level of generality. So in Egbert, the Supreme Court considered the argument that it should decide whether the damages remedy should be created against Agent Egbert himself, and the Court twice emphasized that no, that was not the question, and the question was whether a damages remedy should be created against any Border Patrol agent generally. The analogy here is whether a damages action should be created against TSA agents for their conduct at airport screening checkpoints generally.
How could national security be at risk when the policy itself allowed for reporting of agents?
Your Honor, there's certainly a national security interest in maintaining order at a security checkpoint, and that will require judgments about whether certain expressive conduct is okay or whether it is distracting or disruptive enough to cause a problem. So these judgments are. The policy does say that it is okay to record, but so long as the recording does not become disruptive. So there is some judgments that TSA screeners need to make here, and TSA is very committed to respecting the First and Fourth Amendment rights of airline passengers. It is also committed to protecting us from terrorist attacks, and distractions at this airport security checkpoint can get in the way of TSA's ability to protect us. No, Your Honor. The analysis is to be considered at this higher level of generality, whether the judiciary is, as the court said in Egbert, undoubtedly better positioned than Congress to create a damages action against TSA screeners in this context. And here, there are plainly national security implications to TSA screeners' decisions about maintaining order at security checkpoints. And the prospect of personal liability for making a judgment that falls on the wrong side of the line would influence the way that TSA screeners go about making these decisions. And perhaps that would be for the better, perhaps that would be for the worse, but in any case, it's for Congress to decide.
There's discussion about national security, and I understand that. You've answered some questions about that. It is, you know, does the purview of TSA also relate to general aviation safety in a way that doesn't have to address national security?
I'm not sure I understand your question, Your Honor. I think general aviation safety is also the concern of FAA, for example, but TSA's whole reason for being is national security. No, Your Honors. We ask this court to reverse.
Good morning, Your Honor. Jonathan Corbett for appellee. Something that the government just said struck me and is causing me to divert from my planned notes here. It was that TSA is committed to protecting the First and Fourth Amendment rights of travelers. My practice specializes in representing people aggrieved by TSA. My clients have been strip searched, including a child. My clients have been body cavity searched at the side of the airport checkpoint. They've abused the disabled, the elderly. Regardless of TSA as an agency's commitment to the First and Fourth Amendment rights of travelers, people. Yes, Your Honor. Regardless of TSA's agency commitment to those things, the individual checkpoint screeners sometimes deviate from those ideals. And this is to be expected when we have an agency that has 2 million passengers per day going through their checkpoints under a search regime that is as close to the constitutional border of the Fourth Amendment as possible. They're putting their hands on passengers all the time. So we should expect that there are going to be occasions where that goes too far, and there needs to be some kind of remedy when that happens. Now, there's no dispute that Egbert is a disaster for anyone with a constitutional injury caused by the federal government. It severely limits their remedies. And luckily, the court in Egbert did not take that concurring opinions idea that we should just get rid of Bivens. They left the door open, and so we can ask if there is a way to distinguish that case from the instant case. And there is. Egbert at page 9 states that the Supreme Court reversed the Ninth Circuit because of the border security context and because there were no alternative remedial processes. And at 14, it said that there are no Bivens remedies available for First Amendment retaliation claims. Unlike Egbert, appellant is not a border officer, and we have a purely domestic dispute for which there is no real remedial process actually designed to hear these kinds of claims. The district court already made those findings before Egbert came out, that there was no national security or border security context, and that there was no real remedial process. Your Honor, I'm inclined to agree with both of you that the law is not going to look at it at the individual case level. But if we go up just a little bit higher to the job of TSA screeners, they're not engaging in some kind of diplomacy or state secrets or anything along the lines that Customs and Border Patrol end up doing. They're simply airport security. They're looking for bombs and guns and dangerous things. And just because the agency at a much higher level has these national security interests doesn't mean that this. I think that the words national security or national security context are a little bit more narrow than that, because if it were just that, Bivens would never exist. Pretty much every agency deals with some kind of national security, the FBI, the federal narcotics officers that were a part of the original Bivens case itself. Yeah. So I think we have to distinguish between the FBI, DEA agents where Bivens does apply, and then on the other side, these Border Patrol or Customs or Immigrations officer where it doesn't. Where does TSA fit? It's somewhere in between the two of those. And traditionally, courts have given great leeway to the federal government for what they do at the border or with immigrations and so forth. Immigrations decisions often aren't even challengeable in court at all. The government's, the administrative search doctrine, the border search doctrine, all grow from what we allow, what we say that the Constitution gives the federal government almost inherently the right to control the borders in that way. So I would submit to court that TSA is between those two, but it's closer to a general law enforcement type category where they're, the day-to-day is not, it's not finding Osama bin Laden. That's not their goal. Their goal is to. Oh, absolutely not. And at the high level, certainly, if we were to challenge a policy of the TSA or something that happened at a much higher level, I think that national security context may be involved. But to say that the people that run metal detectors are somehow immune just because something serious could happen. Well, I think that to some extent, Bivens jurisprudence has required us to look at the level of the officer. I think that was one of the special factors that the Supreme Court put forth in Ziegler, whether they were the same level of agent as an existing Bivens context. So I think there is a difference. I think that saying that anyone who works for TSA is close enough to national security context that we can't hold them accountable for anything. Your Honor, it is a tough distinction to make. I'm going to be candid with the court that this Egbert case makes it very difficult to figure out where that line is. You know, the concurring opinion by Justice Gorsuch about leaving the door open or pretending to, but not leaving it shut so tight that it's not really likely anyone's going to get through. That may be what the Supreme Court was trying to do here. Although I don't think so. They had no problem overturning Roe versus Wade in its entirety when they wanted to do that. So why wouldn't they overturn Bivens in its entirety if they really wanted to do that? So I think that there is a door that's open here for some kind of claims that are at least close to analogous to that which we saw in Bivens. And here we have a search of a person done by a federal officer. So that's the basis and the core. If I can talk a little bit about the remedial structures that were brought up. The two that were brought up were TRIP and the CRCL. And I think that congressional intent is just lacking there to consider these remedial schemes, at least as appropriate for this. So the TRIP program is for people that are on the no-fly list or some other list wrongly. It's not for someone who, even if they're misbehaving at a checkpoint and are identified by a low-level screener as a problem, can use to get some kind of anything, really. The TRIP process is also entirely opaque. You submit a complaint to TRIP, they send you back a yes or a no, and that's it. You don't get any right to submit evidence, to argue, to even to hear why a decision was made.
You may be right, but I didn't realize, I appreciate the no-fly list context of TRIP, but is it the case that only people who are wrongfully on the no-fly list can take advantage of that procedure, or can people who are delayed, who are not on that list, take advantage of that?
My understanding is it's only for the TSA's listed passenger. There are a few lists other than the no-fly list. They have another list called the selectee list, which is people who they think are dangerous enough to list, but not so dangerous that they can call them a terrorist who can't fly. I believe there are actually several other lists that you can challenge. But if you're not on a list, delay is not one of the things you can complain about. You can't go and say that my screening took too long to the TRIP program. That's just not a part of it. The CRCL program, again, the question that I think is relevant here is whether Congress intended that to be some kind of remedial scheme here. And essentially, they created a complaint box, and that's it. There's no right to a hearing. There's no right to participation. There's no right to a finding of anything. There's not even any, as far as I understand, ability for the people that review CRCL complaints to discipline a TSA screener or to provide any sort of remedy other than a recommendation or an investigation. The remedy that was approved in Egbert is very bare bones. The dissent in Egbert harshly criticized the majority for it, but the remedial schemes proposed here by TSA are less than the bare bones that were found in Egbert. They are essentially nothing but a complaint box. I'd also like to bring up to the court that essentially for certain types of claims, this is the only avenue because TSA also claims that Federal Tort Claims Act does not apply to them at the checkpoint because of the intentional torts exception. So assuming the government has its way here, as well as with its argument in other cases regarding the FTCA, essentially this would create a situation where TSA screeners are entirely immunized from judicial review, and that's no matter how badly a person is injured, no matter how intentionally it was done, as long as the government requires that the claim go before it rather than through a state law claim, which it can under the Westfall Act, there's simply just no judicial review. I'll close with this unless there are more questions. Egbert on page 1 says that, quote, in all but the most unusual circumstances, prescribing a cause of action is a job for Congress, unquote. Here we have a federal agency that touches 2 million Americans daily with the search practices going right up to the limit, asking the court for essentially absolute immunity for intentional constitutional torts, no matter how egregious, and without a real administrative remedy existing at all. That's an unusual circumstance. That is the most unusual circumstance that I think that the court was talking about here. Providing something for these people through Bivens is the only means that we can use to vindicate their rights. So essentially the court would be choosing, or not choosing, but maybe feel compelled to remove all remedies at all. And that's not going to protect travelers. That's not going to protect our national security. Our national security isn't vindicated by having TSA screeners make up their own rules and apply them to people at the checkpoint randomly. While these screeners were busy yelling at my client for doing something he was allowed to do, they're distracted from doing something else. I welcome any further questions. Thank you, Your Honors.
Very briefly, Your Honors, on the question of what level of generality is the court supposed to focus, I just wanted to direct the court's attention to page 1805 of the Egbert ruling. And it actually cites, first it discusses the Ninth Circuit ruling, and then it says that the specificity that the Ninth Circuit applied was, quote, deeply flawed. And then it cites actually a 1987 decision from the Supreme Court, Stanley versus United States. And if you go to that opinion, there's a longer and more helpful discussion of the various levels of generality that one could assess this Bivens question, the special factors inquiry. And Egbert sums up that ruling as saying, under the proper approach, a court must ask more broadly if there is any reason to think that judicial intrusion into a given field might be harmful or inappropriate. So I think it is really at its most broad. It is whether extending into the realm of TSA is potentially harmful or. Yeah, I think, on the one hand, that may very well be true and may very well be a bad outcome that is facilitated by the fact that Congress has not created a cause of action. I think the harm that causes, whether that's true, is actually a more appropriate question for Congress and is itself a special factor counseling hesitation. But I don't know that it's true. It may be true for constitutional violations. That's certainly what the Bivens jurisprudence is saying. That's what happened to every claimant in all of these Bivens rulings, is they end up with no cause of action. But state intentional torts or other remedies or the alternative remedies that Congress might provide, no matter how insufficient they are, what it comes down to is that this isn't a job for courts, this is a job for Congress. And so it may be that calling out that a claimant has no right is the most that a court can do, and indeed that is what the Supreme Court has done in many cases. I think that's correct. Yeah, I think if you go to Egbert and Stanley, the 1987 decision, you can go to the level of specificity of this complaint, TSA's employees doing searches more broadly, TSA employees in airports more broadly, TSA itself. And I think the question really is at the most broad. Is expanding Bivens to an entirely new field? And that's back to this is a new context. This is a new field. That's the first step of the inquiry. Is expanding into this new field of allowing claims to proceed against TSA employees, is it potentially harmful? Is it going to have these system-wide consequences? That's the level of generality that is appropriate. Thank you, Your Honors.
A few points, Your Honors. First, with respect to the allegations of misconduct my friend mentioned, TSA deplores harassing or discriminatory conduct of any kind, and those actions would be completely contrary to law, policy, TSA's commitments, and the training it provides its agents. TSA screeners who have engaged in misconduct have been disciplined, fired, and prosecuted for misconduct at the airport security checkpoints. So the lack of a Bivens action here does not mean that TSA agents are free or are able to violate people's rights. Second, with respect to the alternative remedial scheme, the court made clear that the question is not whether the alternative scheme would address the particular plaintiff's injury, but rather whether the political branches had provided what they considered to be alternate remedies. Third, the court considered and rejected the argument in Egbert that Agent Egbert was not, I see that my time has expired, that Agent Egbert was not involved in any high-level national security policy, foreign policy issues, but rather, as the court put it, was a rank-and-file Border Patrol agent, and this was, as they said, a conventional excessive force claim. And still, the question of national security was implicated because they were deciding whether to create a cause of action against Border Patrol agents generally. Thank you.
Your Honors, good morning. May it please the court, I'm Elliot Buckner here on behalf of, the appellant, Sean Curran. We are here after the district court concluded that this case requires a special relationship and then granted the motions for summary judgment filed by the defendants. The court did not reach Axon's motion regarding vicarious liability, employee relationship, agency relationship, independent contractor relationship, nor did the court reach Axon's argument that there is assumption of the risk on behalf of Mr. Curran. What we're here on today, what's before the court, is really two questions. The first is, did Mr. Nelson, the individual we allege was Axon's employee or agent who was conducting this taser training, the conducted energy weapon training, did he owe Mr. Curran general negligence duties? The second question is, was there a special relationship that created those duties? Those two questions are not mutually exclusive. Both can exist under the circumstances of this case. Both were alleged, and Mr. Nelson has duties under both of those. We've laid out.
Your complaint, do you allege that Nelson owes a duty of general negligence, and what's that duty?
Your Honor, we alleged very broadly under the notice pleading standard that in paragraph 15 that at all times hereto defendant was negligent, grossly negligent, and willful and wantonly negligent. Then the following paragraph 16 of our complaint, where we allege, among other things, he failed to exercise reasonable care, failed to properly set up the training area, and then went through a list of other things that he failed to do, all of which support a general negligence theory. Below that, we allege a special relationship. The distinction between the two, and the important and crucial distinction between the allegations in the complaint and the paragraphs in the complaint, is paragraphs 15, 16 only allege things that would support a general negligence claim. That's his active conduct that he did. With the special relationship, it's the conduct of a third person. That's the very nature of the special relationship, that he has a duty due to his special relationship to control the actions of a third party. So that's the distinction in the complaint. We also made it very clear in the district court that we were alleging both. We requested an opportunity, to the extent the court thought we only alleged a special relationship duty, an opportunity to file an amended complaint. That was denied, and ultimately we ended up here. We've detailed a number of facts in our pleadings. They've detailed facts in their pleadings and the briefs that we filed with this court. And I'm not going to go through all of them today, but I think it's important because this is a factually intensive case. The decisions made by this court depend on those facts that have been alleged and the facts that are both undisputed and disputed. Mr. Curran was attending a 2-day Axon training class related to teaching other officers how to use tasers. It's a 2-day class. It was conducted by Mr. Nelson. Mr. Nelson was there on behalf of Axon. The class was arranged through Axon. First day class is all in a classroom. It's using a 357 slide Axon presentation. They go through that in the class. Then day 2, and that's when the incident occurred where Mr. Curran was struck in the eye and severely injured. That is more of the live action where they do live firing, and then they go into these scenarios. The court's been provided with video clips of the actual scenarios where there was a box drill set up with wrestling mats. The aggressors, Mr. Curran was one, there was a second aggressor.
Been through some of that, and I appreciate you providing it, so feel free to resume that. But in the briefing, the legal issue of negligent training or negligent supervision comes up. Is it your position that you allege a claim for negligent training or negligent supervision?
No, Your Honor. We have not, the use of the word supervision in our complaint was not intended to allege what I think people classically think of as a negligent supervision claim. When we look at negligent supervision cases, what we usually see is it's in the employer failing to monitor or supervise their employee, who then does something to some third party. In this case, the supervision we're talking about is Mr. Nelson's active monitoring, control, administration, his function as the overall head of this training. That's the supervision we're really talking about in our complaint. We're not claiming that there is an independent cause of action based on negligent supervision. The duty we allege is a general negligence duty and a special relationship duty. The general negligence duty, yes, Your Honor. Okay. The general negligence duty that we allege is what is, I think, very clearly laid out in the RGR case. 4 years later, it was confirmed in the Quisenberry case. The RGR case, I don't think broke new ground. What it did is say, here is 100+ years of tort jurisprudence. Here's the general duties. And they say a duty of care is ordinarily owed to avoid conduct that creates risks of harm to others. The general duty is owed to those within reach of a defendant's conduct. Whenever one person is, by circumstances, placed in such a position with regard to another, that if he did not use ordinary care and skill in his own conduct with regard to those circumstances, he would cause danger of injury to the person or property of another. A duty arises to use ordinary care and skill to avoid such injury. And RGR goes on to discuss this duty owed to all mankind. But
Still that, the duty to take affirmative action to protect the participants in paragraph 17 of your complaint, which is the paragraph that talks about a special relationship. Is there some other place in your complaint that sets out the duty?
well, Judge, I think
Other than paragraph 15, which just broadly says he was negligent.
we did not specifically say that he owes a general negligence duty, and then we did not go on to say, and separately owes a duty of,
So not only, so the allegation of duty in paragraph 17, the special relationship paragraph, is where you set forth the duty?
respectfully, no, Your Honor. I believe it is set out in 15, because I think, yes, Your Honor, when you say the word negligence,
That encompasses everything?
it has to. It has to, Your Honor. Negligence has to include that.
Well, why is it 16, the area where I would expect you, in response to Judge Thacker's question, that point, not just 15, but the 16?
And Your Honor, I had mentioned that previously in response to one of Judge Thacker's questions, that I think it's in 15. I think duty is one of the requirements of negligence. But 16 also lays out the failure to act reasonably. It talks about,
It's really more failure to act than actually specifying duty, but the things that are referenced there are more in line with general negligence, I guess, is your position.
yes, sir. Yes, sir. And while I would have to concede that that probably can be characterized better as breaches of that duty, it necessarily implies that there is a duty that exists if it has then been breached. And while RGR talks about this duty to all mankind, it puts some limitations on that. There's got to be sufficient juxtaposition between space and time, between the actor and the injured. In this case, there's no question that there's sufficient juxtaposition. They were in the same place within feet of each other when all of this occurred, Mr. Curran and Mr. Nelson. They also talk about foreseeability, and that while foreseeability doesn't necessarily define the duty, it doesn't establish the duty, it does help define to whom that duty is owed. And I think the statement that's in RGR is exactly what covers this case. Whether reasonable care was exercised depends upon what a reasonably prudent person with knowledge of the circumstances ought to have foreseen in regard to the consequences of his act or admission. However, the precise nature of the consequences need not be foreseen. It is enough if the act or omission is such that the party ought to have anticipated that it is liable to result in injury to others. And I think that's important because of the way the defendants in this case, or the appellees at this stage, are trying to frame the issue in this case. They're framing it as this narrow injury to Mr. Nelson's eye. But that's not what the duty was. The duty was for to Mr. Curran's eye. The duty was for Mr. Nelson to conduct himself in such a way that he did not increase the risk of harm to others that were sufficiently juxtaposed in place and time. That was really a duty owed to everyone in that room. And if your honors have watched, it's really more, Judge, the relationship between Nelson and the trainee who discharged the taser that is the relationship that requires him to have, to exercise some control over that individual. We allege that there is a special relationship that gives a duty to Nelson that was then breached. And it's a duty owed to Curran to protect him. I should be more clear in the way I say that, Judge. He owes a duty to protect, Nelson owes Curran a duty to protect Curran because of the relationship, the ability to control. That's what the Shoemaker case is all about, Judge. The Shoemaker case, which says Restatement 318 applies here in Virginia. The Shoemaker case was the grandparents who permitted their adult grandson to fire his rifle on their land, knowing that he was firing it in the direction of their neighbor's house. They were in the house or around. The court said in the vicinity, and that was good enough. And the court said that they had a duty to control their grandson before he fired his rifle into the neighbor's house, killing one of the people inside the house. Yes, Your Honor. Yes, Your Honor. But,
And on the special relationship aspect, does it matter? I think that the restatement applies to the possession of land in addition to the ownership of land. Is that correct?
yes, Your Honor. And in Shoemaker, and actually footnote 1 of Shoemaker, it says it's not title owner of the land. It's possessor of land or possessor of chattels. We actually have both in this case. Mr. Nelson possessed the gym. He was the one that had full control over what occurred in that gym that day. He had the ability to set up the mats. He had the ability, he handed out the tasers. He had the ability to take the tasers back. He had the ability to send people out. He controlled that piece of land, the gym, that day. He also, because of his control of those tasers, he controlled the chattel. He controlled the means by which this injury occurred. I think this case falls squarely under Shoemaker. If we change Shoemaker's facts just a little bit to make them more analogous to our facts, and I see that my time's out, may I finish my thought? If we change the facts of Shoemaker just a little bit to make them more analogous to our case, I think it becomes very clear that Shoemaker applies. If instead of Shoemaker's being, the grandparents being in the vicinity and just permitting their grandson to set up and shoot and having knowledge that he was there, if instead they set up the targets, they gave him the rifle, they told him where to sit, where to stand, where to fire from, they told him the direction to fire in, and they were standing right next to him when they did it, that's closer to our case than the actual facts in Shoemaker. Thank you, Your Honors.
Good morning, Your Honors. May it please the Court. Pam Peterson, here on behalf of appellees Axon and Mr. Nelson with my co-counsel, Brian Casey. This Court should affirm the District Court's grant of summary judgment to Nelson, and by extension to Axon on the vicarious liability claims on either of two grounds, either of which is equally compelling. First, as expressly held by the District Court, Virginia law does not recognize a cause of action for negligent supervision, and further, does not recognize the existence of a special relationship between an instructor and a student, giving rise to a duty to protect from third-party harm. Thus, Mr. Nelson owed no duty to intervene to protect the plaintiff from his fellow trainees' actions. And second,
Even when Mr. Nelson set up a special safety area and told them they could remove their helmets in that area?
Your Honor, there was a recovery area that was set up for the role players in between active scenarios in which Mr. Curran claims that Mr. Nelson told him he could take his helmet off during the recovery period. He acknowledges, however, specifically in his testimony, that he had the ability to have his safety glasses at the bench and was well aware of training protocols that required the use of safety glasses or some type of protective eyewear at all times by all persons anywhere in the training gym, whether or not you were inside the blue mats or outside of the mats.
There's a question and answer at JA 676 and 677, wherein he was asked whether he was aware he needed to have the safety glasses on in that area, and he says no.
Well, he was aware, Your Honor, and very specifically, I think it's important to note here that Mr. Curran was a very experienced law enforcement officer who not only was going through instructor training during this particular exercise, but had gone through TASER certification training on 9 separate occasions. At every one of, yes, it is. These are express testimonial admissions of Mr. Curran during his own deposition testimony. No, Your Honor. The only claim that was dismissed at the Rule 12 stage was the direct negligence claim against, for failure to train, against Axon. The claims at issue here are based on fully briefed summary judgment motions. And in that situation, the court determined that there was no duty owed for third-party action and no special relationship relating to Mr. Curran and Mr. Nelson, and by extension, the vicarious liability claims to Axon. There was never a contributory negligence argument made. We fully briefed, and it was responded to by plaintiff on the merits, an assumption of the risk argument on summary judgment that was fully teed up. It was before the court, and it was based expressly on Mr. Curran's own testimonial admissions. And plaintiff, of course, acknowledged. He didn't, because he didn't need to because of the no duty ruling. He didn't need to reach that. This court, however, as Judge Diaz acknowledged in the earlier argument, has the discretion to decide issues that weren't decided below. Either way, I think there's an overlap clearly between the assumption of the risk and the duty issue because of foreseeability and other issues that are at play here. But let me. Sure.
And Virginia law seems pretty clear to me that there can be a special relationship. So, or that there's a cause of action for, that arises when there is a special relationship for the acts of a third person. So those two things, I think everyone agrees, maybe I'm wrong, are in Virginia law. And so, as I understand the district court, its decision was based on the fact that there was no special relationship.
Well, that's right. And because, as Judge Thacker pointed out, that's what was alleged in the complaint.
It may be, and that's a fair argument. Certainly, paragraph 17 suggests that language. Your colleague says paragraph 16 and 15 suggest a general duty. And it gets a little bit to Judge Diaz's question about, is this a complaint issue or is this I realize it all came about in the context of summary judgment, but what are we talking here, the existence of law or what has been alleged?
Yeah. Well, I think both. The district court certainly found that Mr. Curran's claims were expressly grounded in special relationship, and that there was no other claim alleged in the complaint. And I think that that's exactly right. If you look at paragraph 17, he alleges that a special relationship existed between Mr. Curran and Mr. Nelson. It's not pled in the alternative. That's simply what it says. Yes, and that he negligently failed to protect Curran from harm caused by a third party. So that's what. So in paragraph 16, there is some specific allegations relating to certain failures, not affirmative action, but certain failures. That goes to supervision. There is no negligent supervision claim under Virginia law. I think it's important that even though Mr. Curran alleges that Nelson set up, oversaw, implemented, ran, and supervised the
So if I take my clerks to a shooting range, we want to practice shooting, and one of my clerks is a horrible shot, and they say, all right, other clerks, go sit down there behind the target and keep your goggles on, but otherwise keep your eyes out. I mean, is that not something that there would be a cause of action for in Virginia?
If the allegation is, and the cause of the harm is that the failure to supervise those students or those people with whether they were wearing their goggles or not,
Just failure to, exercise due care in the operation of your business that's got some inherent danger.
there is nothing inherently dangerous about the way that Mr. Nelson set up and ran this scenario. And I want to make it clear that this scenario has been run in tens of thousands of training classes with people involved in it. Nobody has ever before Mr. Curran had an eye injury in connection with any of that. But I think that in this situation, there's nothing inherently dangerous about the way that it was set up or the fact that the activity went from outside the box, and was fired from outside the box. And that's because in these training incidences, you have cartridges that are being used that are not energized. There's no electrical current flowing from them. They have a quarter.
And those may be great arguments, and they may cause you to win the case. I'm just struggling a little bit with the assertion that there's no duty when you're setting up a training program that involves the use of tasers, which certainly I think anyone would concede if they hit a person without protective gear on could cause some harm.
Well,
Why there's not some duty arising.
Well, we have never denied that there's a general duty of care. Mr. Nelson had the obligation to exercise due care in his own conduct to avoid injuring other people. He did not have the duty, absent a special relationship, to protect Curran from the actions of others, which is what happened here. And I think when you look specifically at what are the but-for causes of this injury here, right? So the but-for causes, there's perhaps two of them. One of them is that the action went outside of the box and the third party discharged his taser weapon with Curran downrange. And the allegation is that Mr. Nelson was negligent in not calling stop action and stopping that thing from happening. That's supervision. That's a negligent supervision claim, which is very clear, does not exist in Virginia.
What if Virginia has a minor league hockey team, and they don't have any plexiglass around in front of the seating arena? Is in the puck, the hockey player tries to shoot towards the goal, hit someone. Is that a special relationship case, or is that a general duty that you need to, hockey pucks can injure somebody, and you have a duty to put up plexiglass to have a reasonable safe environment?
Well, that can be a general duty type of a situation, Your Honor, but again, is it the action of a third party? There, the law is clear, you have to have a special relationship.
Party cases, most of them that I look at, certainly the Burns case says this, seems to be, I don't know if this is a requirement, that usually it's a third party that's doing something either illegal or at least wrongful. And in my hypothetical, the hockey player's just playing the game, just the puck got away. And arguably here, I don't think we know the name of the person who fired the taser, but we do, and I missed it, I'm sorry. But whoever fired the taser, he missed, so, that he might not have been a good shot, but I don't think there's an allegation he did something wrongful that I see in those
Yeah, well,
third party cases.
I think that everybody agrees here, there was no criminal or intentional conduct by that trainee, but I think it's very interesting that in the plaintiff's opening brief at pages 31 and 32, they actually say that that trainee wasn't even negligent. So query, if the trainee in firing the weapon with Curran downrange was not negligent, then how was it negligent for Mr. Nelson to not intervene to stop a non-negligent act? I mean, that just doesn't make any sense. You've got Mr. Curran, who, again, the second but-for thing is that he took off these safety glasses. And the evidence and his own testimonial admissions are just astounding in this regard. He'd been through 9 separate training incidences in which he got the warnings. He testified he expressly knew of permanent eye injury risks. I think that's right, but there's also in the analysis relating to Section 318 of the restatement and the Shoemaker case, there are some special requirements relating to that plaintiffs overlook and that the district court specifically found factually did not exist here. And that is that it's not enough that you are present and that you have to have additional factors in terms of having a duty for third-party harm. That in Shoemaker they found, yes, the grandparents had a greater knowledge about their property, they had a direct line of sight to what was going on, and they had the ability to control their grandson. The district court here. Well, he had, certainly, again, he had a general duty to, in his own conduct, to not do things that would necessarily injure others. But again, the only allegations here as to what actually there's causation, relating to that is the failure to cause stop action and the failure to apparently warn or remind Mr. Curran that he needed to put on his safety glasses when he took off his helmet. Those are both supervision. Those are both negligent supervision things. There's nothing about the setup or the running of the scenario in general that applies under negligent standards. And Judge, no, Your Honor, not in terms of a third-party action and a duty to protect. I think that's very clear. You had to have had, Mr. Nelson had to have had the awareness of the need to take action to protect Mr. Curran. And it is undisputed in this record, and the district court found that Mr. Nelson could not see Curran at the time of this incident. And not only was Mr. Nelson testified he could not see him, his line of sight was unlike the grandparents in Shoemaker. And Mr. Curran, who this was his home base, Jim helped him set everything up. He had the same knowledge, certainly as Mr. Nelson did, but it's undisputed, and I think the court. Well, under Section 318, you had to have had the ability to control the situation. You had to have awareness of the necessity or the need to do it. And the district court here found that those things did not exist. And I don't think those factual findings are erroneous, are clearly erroneous. Because in this situation, well, it's not when he set the whole thing up, it's when this injury actually occurred. This was a scenario that took 10 seconds. And it's undisputed that there was no direct line of sight. He didn't know where Mr. Curran was and didn't see whether he was wearing eye protection at that particular time. So the court found there was not any evidence of an awareness that he needed to take any action to protect him. But certainly, again, just the fact that the action goes outside of the mats doesn't make it inherently dangerous if everybody's wearing their eye protection, which Mr. Curran absolutely knew was a requirement at all times in the gym. So at JA 648 through 49, I don't believe so, Your Honor, because he specifically testified that he knew the protocols for wearing the eyewear had to be at all times. This had been this. Well, Mr. Nelson specifically testified that he never told Curran that he could take off his helmet and not put on his safety glasses. And even Mr. Curran's testimony does not go that far. It doesn't go that far. He specifically testified he knew that the entire gym was designated as the training area and anybody entering the gym needed to wear protective eye gear. He knew that. And these were the same protocols that he said applied in every single other training. I don't believe so, Your Honor, because I think that respectfully, Your Honor, he got all of the warnings that talked about permanent eye injury risks and the protocols very clear. He was issued safety glasses. He wore them earlier on that same day in doing the live action firing drills, and he testified he was able to have those safety glasses at the bench with him. All of the testimony that talks about the recovery area being able to take off of your helmet is based on between active scenarios, not during an active scenario. And this experienced officer clearly knew of those risks. And had he been wearing his protective eye gear, this incident wouldn't have happened but for that situation. Thank you, Your Honor. And I don't have anything, we were just reserving a couple minutes for him just in case you had specific questions, but otherwise I think we've covered it. Thank you.
Thank you, Your Honor. I don't know that I could do that again if I tried 10 times. That's right. Your Honors, we heard a lot of facts just now stated as facts not in dispute. But every single fact that was stated is in dispute in this case. That's one of the primary problems that we have with being here today on motions for summary judgment. There are a ton of material facts in dispute. For example, it was stated that as fact, Mr. Nelson couldn't see Mr. Curran when the incident that ultimately took his vision in his eye occurred. That is betrayed by video clip number 7, which has been presented as part of the joint appendix to this court. At the beginning of that scenario, Mr. Nelson is standing behind the mat where he can see Mr. Curran. As the scenario unfolds, he walks in front of the mat. So it's our position. He knew he was there. He could see him, knew he didn't have his helmet on, knew he didn't have his glasses on. The question of whether Mr. Curran was supposed to have his glasses on, or Mr. Curran was supposed to have his glasses on, he has testified unequivocally he wasn't. He was in the safe zone. That was okay. He didn't have to have his glasses there. We also have supporting evidence for that in joint appendix 92 or 798. It's the same picture, but it's the picture of the other aggressor. What we see in that picture is the second aggressor.
Matters of law. And so I thought that's what we're here about. I thought I didn't think the district court ruled that there was no genuine issue of material fact about breach or causation. So am I wrong?
Your Honor, I think you're exactly right. I think the problem that we've got, or at least that I've got today, that we had during our briefing and that we had down below is that the appellees have gone a little bit beyond what the scope of the issues presented to this court are by arguing assumption of the risk, by arguing other things that aren't the genuine issues that bring us here today. I absolutely agree with you, Your Honor, that the issues we're on here today is, was there a duty? And I think the reason that we're here is the district court simply didn't look at general negligence principles. The district court looked at this solely as a third-party actor and the responsibility or the duty of Nelson to control that third-party actor. I think that's what the court looked at if you look at the court's ruling. And I think that's the case because in their order, we really only see RGR, Quisenberry, talked about, I think it was just in a footnote. So I think what we're here on today is duty, Judge. I absolutely agree with you. And I think when you look at general negligence principles under RGR, Quisenberry, I think we squarely fall underneath that. You look at the principles requiring a special relationship where Shoemaker comes in, I think we're squarely underneath that. And I think just a simple change in the facts of this case illustrate why both of those apply. As part of this training scenario, every single trainee that came in had to be screened to make sure they didn't have any weapons on them, other than their taser.
I think the issue for the district court was where that was alleged in your complaint. I think the district court focused on where you were most clear about duty, and that's the special relationship in paragraph 17. And you're pointing to paragraphs 15 and 16. And for me, the question is whether that's good enough to allege this general duty that does exist in Virginia.
I think you're right, Your Honor. I think that is.
So why are paragraphs 15 and 16 good enough?
I think 15 on its face with an allegation of negligence includes duty, breach, damage. I think it.
Everybody learns that negligence equals duty, breach, cause harm in law school, and so just saying negligence covers everything. Is that your?
Yes, Your Honor, and that's candidly what the Virginia rules permit, that a statement of negligence is sufficient in itself. And I think it's because of that very reason, that when you say someone was negligent, it necessarily requires those three elements. Then the very next paragraph, 16, provide.
Does it require you to set out those elements in your complaint?
I don't believe that it does, Your Honor. I think a simple statement of negligence is sufficient. I think we do have to ultimately state what our damages are in our wherefore clause, which we've done. But I think a simple statement of negligence is sufficient to put the defendants on notice. And our complaint went well beyond that. Our complaint lists a lot of facts before we ever get to the allegation stage about what happened in this, what the breaches were. Those breaches are clearly breaches of a general duty. So I think duty is included in our complaint. Both duties, the general duty and the duty based on special relationship. And if the court wants to just push special relationship to the side, put it on a shelf and take a look at the complaint without it, I think the complaint is sufficient just on general negligence theories. But we never got there before. We just never got there. We went down this, reluctant to call it a rabbit hole, but that's kind of what we did. And we heard some of that today, that it's this constant kind of pushing over to, it's got to be this control of a third party, and it doesn't. Again, just to change the facts of this very quickly, as the trainees came into the gym, they couldn't have weapons on them. Mr. Nelson required that everybody be screened for weapons so that they didn't bring in a pistol and fire that instead of their taser at someone. What if, as Mr. Nelson is screening these people, he misses somebody as they come in? Somebody comes in with live rounds loaded in a handgun. He's monitoring them, administering the training, overseeing it. He's standing right next to them as they go through the live action. He sees, oh, I forgot, that guy's got a handgun. He does nothing. He sees them put their hand on the handgun as the action's going. I see that I'm out of time. May I finish? He pulls that handgun. He sees him do it. He's standing right there. He sees the aggressor coming towards him. He sees his finger go to the trigger, and he squeezes the trigger. 7 different steps where he had not only the opportunity, but the duty to do something because he was in charge. He was the safety officer. Those are his active acts of negligence under general negligence principles. And at the last moment, before he squeezed that trigger, he had a duty to control that person under the special relationship because he controlled the chattel, he was present, and he knew that doing so could cause harm, or failure to do so could cause harm. Thank you, Your Honors.
Today, just as visual aids to point to cover, because I don't think that I could do it justice by just giving you a page reference.
Mr. Reinstein, we did consider that motion. The court has denied the motion. We have the JA in front of us, and you can point us to the sections of the JA. So come on up.
Sorry about that. Oh, sorry. Where's, hold on. Had it in my hand, would I? Sorry.
Counsel,
Yes.
can you please put a microphone cover on? There's extra there next to the podium.
Was that?
Microphone cover.
Oh, okay.
Thank you.
Good morning, Your Honors. May it please the court, my name is Jason Reinstein, and I'm honored and proud to be here this morning to explain to you why the disbarment judgment in the Maryland case, which was based upon an amended set of allegations, first appearing in a 72-page pleading referred to that I may call the draft opinion, to which the appellant never had any meaningful opportunity to respond, should not be accepted by this court as the basis for imposition of reciprocal discipline. I'd like you to consider, please consider the following analogy. Imagine a basic hypothetical scenario. There's a case in which the defendant is alleged to have driven negligently on Monday. The defendant is defaulted and deemed to have admitted the allegation that he drove negligently on Monday. After the default, the opposing party tacks on a new allegation that the defendant also drove negligently on Tuesday. The defendant has provided no trial, and the opposing party offers no proof with regard to its allegation regarding Tuesday. Nonetheless, based upon the erroneous proposition that the new Tuesday allegation had been covered by the deemed admissions, the court proceeds to find the defendant culpable of driving negligently on both Monday and Tuesday, and then imposes a judgment based upon the totality of its findings, i.e. that the defendant was culpable of driving negligently on Monday and Tuesday. I'd ask the court to consider whether there's a problem there, and I proffer, Your Honors, that there is. It's a fundamental constitutional principle that unless a party waives or forfeits his rights, he is entitled to notice and opportunity to defend before judgment is entered against him. The Supreme Court has indicated forcefully that even in a civil case involving a sophisticated corporate party, the rudiments of due process, notice of charges, and a fair opportunity to be heard are not lightly presumed waived. And that was in D.H. Overmeyer versus Frick at 405 U.S. 174, 186, quoting Ohio Bell Telephone Company versus Public Utility Commission 301 U.S. 292. We do not presume acquiescence in the loss of fundamental rights. Waivers and forfeitures are construed narrowly. The constitutional protections and aforementioned principles are even more so true in quasi-criminal cases such as the one at hand than they are in civil cases. And I'd cite this court to Ruffalo at 390 U.S. 544, 1968, In re Williams, 464 A2D, 115, 119, D.C. 1983, and In re Pearson, 628 A2D 9499, D.C. 1993. What happened in this case is largely analogous to the hypothetical scenario about the Monday and Tuesday driving allegations that I described above. No trial occurred, and no evidence was introduced in the Maryland case. Yep. Thank you, sir. Yep. And so that's actually why I had asked, and I apologize again, Your Honors, for filing a motion on Monday night, or Tuesday night rather, about the demonstrative exhibits for today. I had actually looked to Federal Rule Appellate Procedure 34G for guidance, and it doesn't read as if a motion is required. It reads that as if it's at the discretion of counsel, and there was no local rule that I could find that provided additional guidance on that. It just says, if you wish to do it, make arrangements ahead of time. And so that's why. Okay. So, okay. Well, the demonstrative exhibits that I would have shown, and I'll just give you the examples then. The excerpt from the Maryland charge and document at page JA 124, paragraph 64. This shows the only averment that had been deemed admitted regarding the COSA opinion. On November 17, 2014, the Court of Special Appeals filed an unreported opinion, Imagine versus Moore. The court reversed the circuit court finding and remanded the case for further proceedings. Now, let me tell you what the Maryland decision said about the COSA opinion. At page JA 57, in November of 2014, the Court of Special Appeals filed an unreported opinion, Imagine versus Moore, September term 2011. That tracks what I just read you that was part of the admitted averments. But this is where it goes off the rails into new allegations. Rejecting and all of respondents' arguments, which according to the admitted averments, the court found to have no merit. The court rejected the respondents' arguments in support of the motions to dismiss, finding his legal theory to be mistaken. The court found that the Moores had adduced no evidence to support their theory on the merits of the case and concluded the respondents' arguments to have no merit. In a footnote, the court cautioned the respondent for filing a brief in violation of Maryland Rule 8503D. None of that stuff that I just read you was part of the admitted averments, but the Court of Appeals didn't entertain any challenge to it in Maryland because they erroneously thought that it was. It was like that allegation about negligent driving on Tuesday that's tacked on later. As I showed in the appendix to the reply brief, there's three sections, the draft opinion in this case, which is a pleading that was filed at 3:50 or 3:33 p.m. on Monday, July 9th, 2019. The only thing I was allowed to do to respond to it was offer oral argument beginning at 9 a.m. on Wednesday morning, a 72-page intricate document. The three sections entitled Conclusions of Law, Findings of Fact, Conclusions of Law, and Aggravating Factors. Those three sections, which are the ones that materially got adopted with no evidence by the court in Maryland, or no trial, had 121 new allegations, in addition to the 67 that were originally covered in the Maryland charging document. And that's the document, by the way, at JA 108 to 106. That's the Maryland charging document, 126. The Maryland charging document is very significant in this case. This case did not involve requests for admissions that were defaulted on. Most of these default disciplinary cases, the defaulting party doesn't just waive the right to defend the allegations of the original complaint. They waive the right to defend everything that was in requests for admissions and genuineness of documents that went unanswered. So oftentimes, so the realm of the scope of the waiver of due process rights or forfeiture is much larger. So then the opposing party can come in and say, oh, you're guilty of all this based on, and the deemed admissions, which are now evidence, are everything that was in the charging document originally, plus everything that was waived in the requests for admissions that were deemed admitted. There were no requests for admissions in this case, makes it very unique. So the Maryland charging document, that 19-page document with the 67 paragraphs therein, that's at JA 108 to 126, it represents the full boundaries, the maximum boundary that of deemed admissions, of things that were capable of being used to draw legal conclusions without giving me a trial. I just read to you one of the, from what was new allegations in the proposed findings document. The proposed findings document, in addition to the 121 new allegations in the three sections I referenced, and by the way, all of them are highlighted yellow in Appendix A to the attachment to the reply brief. Yes. That's exactly right. There was no evidence about it. I never had an opportunity to defend it. I didn't admit anything on those allegations. Those are like the things on Tuesday. There was no evidence introduced. There was nothing. In fact, the Attorney Grievance Commission of Maryland, I wanted to show you their admission on page JA 176, second to last line. No evidence was admitted in the disciplinary hearing in Rhinestone. This letter was dated September 11, 2020. This is an admission of the AGC. The Maryland courts purported to decide this case exclusively on deemed admissions of the averments in the Maryland charging document. But what I'm saying is they didn't actually. The case, I was not disbarred based upon, I was not found guilty of misconduct and disbarred on the basis of deemed admissions of the original allegations in the Maryland charging document. I was found guilty of misconduct and disbarred on the basis of an amended set of allegations that appeared for the first time in the draft opinion filed after the decision to default me had already been made. In addition to covering the original 67 allegations of the Maryland charging document, the draft opinion had incorporated, like I said, 121 new allegations, almost all of which were accepted in the sections that were adopted by the court. And I refer you to Appendixes A and B to the attachment to the reply brief. I literally itemize each one in a table, so they're highlighted for you as a visual in Appendix A, and they are listed numbers 1 to 121 in the table in Appendix B. Appendix C to the attachment for reply brief shows the referee's opinion for Maryland. And it says that it was wholly based upon the deemed admissions, but it shows all of the yellow is stuff that wasn't really covered by the deemed admissions. There was no evidence. That's the infirmity of proof. That's the primary infirmity of proof argument in this case. Ms. Lawless will say, oh, well, the court had agreed to take judicial notice of some document. The judicial notice process was never completed. There was never, first of all, and that's basis for my motion to request records, it will establish that there's no judicial notice request was never entered into the Maryland court record. That was not transmitted to the Court of Appeals. That was not part of their decision. Ms. Lawless would have had to ask that certain facts from those documents. It's not a question of asking about the documents. The judicial notice process requires that you say, you set forth the facts you're seeking to have noticed, and the court can notice them if, the opposing party is entitled to a hearing as to the propriety for doing so, either before or after the facts are noticed. But no facts, specific facts were noticed, established through that process. So I guess the problem is, and by the way, if the court does it sua sponte, the court is required to inform the parties that they took judicial notice of facts and provide an after-the-fact hearing on the propriety. And I'd ask you to look at Maryland Rule 5201E and Federal Rule of Evidence 201E. Just getting back to what I was talking about. I've found guilty of misconduct and disbarred on the basis of an amended set of allegations. So the 67 allegations of the original thing, and the 121 new ones. And Your Honor, you rightfully pointed to, there is a host of allegations about events in 2017. And all that stuff is not covered by the admitted averments. My proffer for you is I was entitled to a trial on that. That's the due process violation. That's the problem. It's not the primary problem. It doesn't matter whether I was the most egregious discovery violator in the world, which I assure you I wasn't, but we don't have to go there in this case. Because this case is about whether or not once you defaulted a party and you amend the allegations, the party gets to still retains his rights to defend the new stuff. And the totality of the circumstances. Oh, sorry. Okay. Okay. Well, I'll finish my thought. I guess I will save everything here for rebuttal. Thank you.
Good morning. May it please the court. Lydia Lawless, court-appointed amicus counsel in this matter. I'd like to just back up a little bit for the procedural history leading up to the July 1st and the July 10th hearings that were held in the Circuit Court for Anne Arundel County in 2019. It begins on June 27th, 2019, when the hearing judge in the disciplinary case ordered sanctions for the first time. That order of sanctions was based on a motion for sanctions that had been filed in July of 2017, a second motion for sanctions that had been filed in the summer of 2019, and a supplement thereto. In ordering sanctions, the hearing judge found that Mr. Reinstein had failed to comply with his discovery obligations and found that sanctions were warranted to the extent of striking the answer that had been filed, deeming the admissions admitted, precluding Mr. Reinstein from offering any evidence at the hearing that was contrary to the admissions or otherwise, and precluding him from presenting any evidence in mitigation. And in Maryland, the disciplinary proceedings are not bifurcated as they are in some jurisdictions. In Maryland, you have one hearing both on the charges alleged. Bar counsel at that hearing has the obligation to prove any aggravating factors, and at that same hearing, a respondent attorney is obligated to present any mitigating factors. Mr. Reinstein was precluded from presenting any evidence. Sure. Yes, so the judge's order in issuing sanctions said, a hearing will be held on argument on proposed findings of fact only. There will not be an evidentiary hearing. And this is within the framework of the Court of Appeals of Maryland in the Thomas case that's cited in the papers to say that where there is a default and where averments are deemed admitted, there is no need for an evidentiary hearing. I have not forgotten your question, Your Honor. I'm getting there. And so what happened was we appeared for the hearing on July 1st. And at that hearing, because it was specifically ordered that it was not an evidentiary hearing, both parties appeared and asked the court to take judicial notice of certain documents. And petitioner's requests for judicial notice consisted of docket entries from the myriad of underlying matters in this case and from the federal removal cases of the disciplinary case and the docket entries from this court of the appeal of the removal of the disciplinary case. Those facts are not in dispute. Those are clearly things that the court can take judicial notice of, the procedural posture, what was filed, when it was filed, and what court it was filed. The other documents that petitioner requested the court take... Yes, Your Honor. Those documents, they were taken judicial notice without objection and without limitation, Your Honor. That's correct. And my understanding of his argument is that he believes that the court took judicial notice of the document to say this document exists, but not judicial notice of every single thing that was contained within the document. There is no dispute that the court took judicial notice without objection and without limitation of those 11 exhibits offered by the petitioner. They were marked in the record, combined as... It is, Your Honor. It is at 1041, I believe. It was at the July 1st, 2019 hearing. If that site is incorrect, it was at that hearing. Correct, and reasonable inferences that were drawn then from the record before the court, which consisted of the petition with the admitted affirmance, the 11 documents judicially noticed, and the inference drawn therefrom. And so there were the... This issue was addressed specifically by the Court of Appeals. And yeah, there was no due process violation in this case. In this case, there were, and if I could direct your attention to so there were the docket entries that were taken judicial notice of, and then the other documents that were taken judicial notice of was the unreported opinion by the Court of Special Appeals and the opinion dismissing the first key TAM action that was issued by Judge Blake of the U.S. District Court. Because an inference, Your Honor, is formed by every fact finder in every case, you know? I mean, when you're talking about questions of knowledge, when you're talking about questions of intent, it is always circumstantial evidence, or almost always circumstantial evidence, to say that he knowingly filed a frivolous filing. That is demonstrated by the totality of the circumstances, whether it be the documents that are admitted and judicially noted, or whether it's the testimony of the witnesses.
And that may be a valid conclusion. I guess what I'm having trouble with is not giving someone facing disbarment the opportunity to respond to the reasonableness of the inferences that are drawn from it.
I think to that point, Your Honor, the inferences were very few and far between. And the inferences generally went to what the aggravating factors were as determined by, in the first instance, the hearing judge. That's correct, but those are not inferences. Those were either established facts about what was filed when, as evidenced by the docket entries, or they were adjudicated factual findings or conclusions of law that were adjudicated. That's correct, Your Honor. That's correct, Your Honor. And they all go to support facts that were charged in the original petition. So it's a notice pleading, and then there was some meat put on it with these additional documents of which the court took judicial notice. So there are no new allegations, and what he claims was this draft opinion was proposed findings of fact and conclusions of law that were filed by a party in the case. It is not a draft opinion by the hearing judge. There was then argument on that document, on the proposed findings of fact and conclusions of law. That argument was held on July 10th, 2019. And counsel for Mr. Reinstein at that argument specifically said this case either needs to be limited to the allegations in the petition plus the 11 documents taken, that the court took judicial notice of, or, as they wanted, the entire record of every single underlying case should come in for the court's consideration. And what the hearing judge said was you lost the ability to do that because you lost the ability to put on a defense. So our record is limited. It was absolutely clear. Everybody understood that the hearing judge's findings of fact that were issued in this case were based on the totality of the charging document, the judicially noticed documents, what was contained in the judicially noticed documents, and the reasonable inferences drawn therefrom. There were no new charges. There were no new allegations. Mr. Reinstein was not found to have violated a single rule of professional conduct to which he was not charged.
I think that the rules in the request for relief in the petition are the same rules that are highlighted or the headings in the findings. So it's the same rules of professional responsibility.
Absolutely, Your Honor. Absolutely. And there was, so the petition was filed in February of 2016. It was never amended. The proposed findings of fact that were submitted by the Attorney Grievance Commission outlined the support for each of those rule violations as charged, withdrawing one of the charges where there wasn't sufficient information in the record to support it. The Court of Appeals of Maryland, in its de novo review of the conclusions of law, found that the record supported each of the charges as charged in the petition. And to Your Honor's question about there was conduct that took place after the petition was filed that couldn't have been charged in the petition, there are certainly findings as it relates to that. Those findings are not part of the basis of any rule violation. Those findings go specifically to aggravating factors that were alleged in this case and found by the Court of Appeals. And the Court of Appeals has recognized, much like every other disciplinary authority across the country, that obstruction of disciplinary investigation or disciplinary proceeding is an aggravating factor, and engaging in dishonest or deceitful conduct during the disciplinary proceeding is an aggravating factor. So where there is discussion in the Court of Appeals opinion related to Mr. Reinstein's post-charging conduct, those discussions are simply go to the aggravating factors. They're not part of the original charges. So there is no due process violation. There is no notice deficiency, and he was provided an opportunity to be heard, and he lost that opportunity based on his extensive pattern of obstruction, dishonesty, and failure to comply with the rules. He was not prohibited in any way from responding. So the proposed findings of fact were filed by the commission. He had argument on the proposed findings of fact. That was on July 10th, 2019 in the circuit court. The hearing judge in the circuit court filed his findings of fact. In the Maryland disciplinary system, all of the cases go back up to the Court of Appeals. It's not an appeal that needs to be taken or otherwise. The Court of Appeals has original, complete jurisdiction over attorney disciplinary matters. So as a matter of course, the record goes up to the Court of Appeals. The Court of Appeals reviews findings of fact under a abuse of discretion or clearly erroneous standard rather, and reviews all conclusions of law de novo. Mr. Reinstein filed, I think it was 155 pages of exceptions to the hearing judge's findings of fact and conclusions of law. He had a full opportunity to be heard. The matter was scheduled for oral argument in the Court of Appeals. He was represented by counsel both in his post-trial submission, his exceptions, as well as at oral argument in the Court of Appeals. He was afforded the full 30 minutes as is permitted by that court. He had every opportunity to be heard, and any deficiency in the record is due to his own misconduct as found by the U.S. District Court in ordering reciprocal disbarment there. If there are no further questions, I would ask the court to affirm the rulings of the U.S. District Court and to enter an order reciprocally disbarring Mr. Reinstein in this court. Thank you.
Thank you, Your Honors. What Ms. Lawless just postulated for you about judicial notice is simply not possible under Maryland law, and that did not happen. I will, a particular import, quote, Maryland Rule 5201 is not a vehicle for the admission of probative evidence, but rather a means by which a court can quickly establish incontrovertible facts. You can't judicially notice things like, I pursued the appeal to this court in the prior case in the removal litigation to delay the proceeding. She's trying to say, oh, well, I'm not entitled to put on evidence that I didn't do that, because if they find that, which they did, and then they use that as a basis to disbar me that factors into the ultimate judgment, it's the cumulative total of... No, yes, well, excuse me. I wouldn't have had any reason to, Your Honor, because nobody was asking that any facts be found from those documents. The law says that taking judicial notice of the documents... Yes, but I've actually given the facts. Okay, I'm sorry, I didn't mean to interrupt you. Okay. I had no reason to object to that, Your Honor, yes. I did not, no, I do not agree with her that I did not object. I do not agree that it was ever before the court. The only thing she asked the court to do was take judicial notice of the fact that these things existed. I would refer you to Abrashamian versus Washington Medical Group at 216 MDAP 386-416, which is notice in court filing. What's that? It's in, what I didn't object to was the court noticing the fact that these documents exist. She was, that would be in the transcript of the July 1st hearing. She did not ask the court to take judicial notice of any facts from those documents. She did not ask, judicial notice cannot be used to establish the truth of the matters asserted in like a court opinion. Because they're not incontrovertible facts. What you take judicial notice of is the fact that the document exists, not the fact that what they say is true. When she never moved the documents in evidence, it wasn't like she's saying, I'm motioning to move this into evidence for all purposes. There was no, it would not, nobody would have had any reason to even believe that these would be subsequently try to use them as if it was, you know, they'd been introduced as evidence in an evidentiary proceeding and so on and so forth. There's case law, it says, notice in court filings does not mean accepting what they say is true, only that they exist as public records. 216 MDAP 386-416. I would also refer you, Your Honors, to AU versus EP at 2020 Westlaw 1922-493 at star 5, Court of Special Appeals of Maryland, April 21st, 2020. The judicial notice rule is applied, excuse me. Maryland Rule 5201 is not a vehicle for the admission of probative evidence, but rather a means by which a court can quickly establish incontrovertible facts. It specifically states in that the court cannot take judicial notice of, in AU versus EP, you'll see, a court cannot take judicial notice of the facts that it's true. So the Court of Special Appeals, for example, rules against me. That doesn't mean that the ruling's correct or that facts stated therein are correct. Nobody would believe, she never represented to the court that she was trying to introduce these for the purposes of, like, that everything in them is true. Of course I would have objected to that. I wasn't on notice that that was something that was intended. That wasn't the process. That process doesn't work like that. And it's no surprise, Maryland courts did not decide this case on if anything had been decided by judicial notice. Ms. Lawless proposed in her proposed findings of fact document that Judge Clavins actually adopt language saying that he had taken judicial notice and that was a basis for findings that were made. Judge Clavins did not adopt that language. If he had taken judicial notice or had he used facts that were judicially noticed in his opinion, he would have done so. So I don't have any objection to the court knowing, yes, these documents exist, but I certainly would have an objection to the facts that, to the notion that, the fact that a court takes judicial notice of the document means every single fact is established that's stated in that document. That is not the law on judicial notice. I talk about this in my reply brief and also in my papers. I have the new motion, the renewed motion to request records. You will find that never made it into the Maryland court record. That was never even transmitted to the Court of Appeals of Maryland, that judicial notice request. That's why I've asked this court to get the entire record from the Court of Appeals of Maryland. Let me, in my final minute, you asked me to point to other instances where it's, I was charged and then things changed. At pages JA 84, JA 86, 87, they said, Reinstein misrepresented, they were disbarring me on the primary asserted basis. I misrepresented facts to Judge Brown in the circuit court in an effort to intimidate my opponents. I'd also point you to page JA 92, Ms. Lawless's sworn interrogatory response Question, identify each and every misrepresentation or false statement that you allege was made by the respondent and which you intend to prove at trial in support of your allegation that the respondent violated MRPC 8.4C. Answer, petitioner does not allege that the respondent made misrepresentations or false statements, period. Never did they allege I made misrepresentations and false statements. What happened was, and if you look at the my briefs, you'll see that Judge Brader at the district court read language into the allegations of the Maryland charging document that weren't there. She did not allege that there was a non-existent federal investigation. She didn't allege whether it existed or didn't exist, and it could not reasonably be inferred either way because they're equally possible inferences. So that would require the fact finder to speculate. The reason she didn't allege that it was non-existent is because she knew that there was actually a pertinent investigation. So that's you know, Judge Brader, when he read the allegations, he read it as if bar counsel, and I've put it in red in my brief, bar counsel had actually averred things they never averred. Had they actually averred the things Judge Brader said they did in his motion for order on the motion for reconsideration, that part would be a different case. But these new allegations also were not all covered. There's stuff in there that wasn't even supported by the 11 documents that Ms. Lawless is claiming. For example, the notion that the private fraud action complaint alleged $17 million in damages. That's nowhere in anything that in the documents she's talking about. It's not in, it's not, yeah. So, thank you very much, appreciate it.
This honorable court stands adjourned until tomorrow morning. God save the United States and this honorable court.